Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, the co-founder of ICAN, Investor Choice Advocates Network, and the co-host of today's episode. I'm pleased to be joined by our guest host today, Sarah Concannon, who is a partner with the law firm Quinn Emanuel. Many of you will know she's a former senior attorney with the SEC in various capacities, and I'm pleased to say she is also a member of ICAN's advisory board. Sarah, thanks so much for doing this.
Thank you, Nick, for having me.
And we are joined today by our guest, Chris Iacovella, who is the CEO of the American Securities Association. Chris, you've been on the program before. Thank you for coming back to talk about your latest lawsuit.
Thanks for having me. Appreciate it.
So we saw the news. ASA has filed a petition in the 11th Circuit, and part of it directly challenges the constitutionality of the MSRB. And I will say, even for the securities nerds who might be watching this, you might have to go brush up on what the MSRB does and why it might be prone to challenge in this way. Sarah, can you give us a little bit of background about the MSRB and why Chris's and ASA's petition might be sort of the moment?
Sure. So I'm going to give you kind of a high-level overview of what the MSRB is, and then Chris is going to tell me where I went astray, because we were just having an interesting conversation before we came on about whether it is or isn't actually a self-regulatory organization. But before we go there, so the Municipal Securities Rulemaking Board, or MSRB, is the primary regulator for investment firms, banks that issue municipal securities, bonds, notes, anything of that kind. So municipal securities are securities that are issued by municipalities, states, cities, and counties, typically, which they do for a variety of reasons, often capital formation, providing liquidity, funding build out and infrastructure projects, and that type of thing. They are traditionally viewed as safer offerings, I think, in a lot of ways, and so they can be quite popular investment vehicles. So the MSRB is charged with regulating the underwriting, trading, selling of municipal securities that finance these types of public projects, and they set the standards and best practices for issuers and dealers in the municipal bond and municipal securities space. So for our purposes, I think the really interesting thing is, despite the fact that MSRB has been around for 50 years, it is a little known regulator, as you said, Nick. And there is kind of this quasi-self-regulatory, quasi-governmental, quasi-private status that it finds itself in. So it is fundamentally a private, non-governmental entity granted authority by the SEC to act within this space under the oversight of the SEC. Member organizations pay fees, and then the MSRB is effectively funded through those mandatory fees and mandatory memberships. So, Nick, you said kind of, why is this case that the ASA has brought of the moment? So there have been a number of challenges to SROs and SR authority, particularly in the enforcement space, over the last couple of years. So kind of in the wake of Lucia and Jarchese and other challenges generally to the constitutionality of things like the administrative courts and the SEC, various parties and entities have become much more inclined to challenge what is the role of these quasi-governmental organizations, and what does that mean? It's also a hot topic right now with Chairman Atkins coming into the SEC because he's kind of been a proponent of bringing the PCAOB and potentially FINRA back into the SEC umbrella. So the couple of challenges in the last year or so that have really been in this space are Alpine and Kim, both of which were challenges to FINRA's authority. So Alpine Securities was hit by a FINRA delisting, or effectively, or kick them out of the FINRA organization, which would be an existential threat. They'd no longer be able to operate as a broker-dealer. They, in district court, countered with an injunctive action to shut down the FINRA enforcement action, saying that FINRA was operating beyond its constitutional authority, and therefore the entire proceeding should be stayed while the constitutionality of this was sorted out. They lost in the district court, but they actually prevailed and got a really nice concurring opinion, which permeates Chris's brief that we're going to talk about on behalf of the ASA, about whether or not FINRA really was acting in a way that, with regard to its enforcement arm in particular, is unconstitutional. So, well, the district court essentially found that FINRA is not a state actor for constitutional purposes, finding that the government doesn't fund FINRA. FINRA performs other functions like administering exams that the SEC doesn't share. The district or the appellate court disagreed, and the appellate court and Judge Walker in particular found that FINRA's activities violate Article 2 of the Constitution because FINRA wields executive power and is not subject to presidential control and oversight. He found that FINRA hearing officers are functionally identical to the SEC's administrative law judges, suffer from the same constitutional infirmities as were identified by the Supreme Court in Lucia. Also said, this idea that FINRA is nominally private simply doesn't fly because, per Judge Walker, it's controlled by the government from start to finish with little or no room for private control. But Kim then followed in its wake, which was another challenge to FINRA authority. In Kim, the district court actually distinguished Alpine in a number of ways, ultimately finding that there was no constitutional issue with regard to FINRA in that case. Specifically finding FINRA's board's not appointed by public officials, relies entirely on its own funding. Neither the SEC nor any other agency controls the actions of FINRA, and that FINRA has a role alongside the SEC in regulating the securities market. And the fact that that occurs does not mean that they're operating jointly. So it's a rife space. It's kind of the perfect time for the ASA to be bringing this type of challenge. And some of the ways that the MSRB differs from FINRA may actually make the ASA's challenge have more legs. Also, the fact that you're in the 11th Circuit, and Chris, I would be interested in kind of what led you to file in the 11th Circuit versus various other potential jurisdictions may ultimately lead to a better outcome.
I think that, thank you for that overview, Sarah, and I want to hear about the case in a minute, Chris, but I do think that it is a good time to go back to sort of first principles on a lot of these entities that are out there. And from reading your complaint, Chris, the MSRB is a weird entity. It is, it claims to be this, quasi that, but it seems to do so when it benefits itself to be one private or government, depending on the context. So let's turn to the complaint. And it's actually not a complaint, it's a petition. You're seeking review of a rule promulgated by the SEC. Can you give us how did you get here? What led you to file a complaint, and what is it seeking to do?
So what we did was, and we're located, our headquarters and where we are is in Tampa, Florida. So that's why we filed in the 11th Circuit. And we also have another case, the CAT case with Citadel against the SEC, filed also in the 11th Circuit. So the reason why we got here was because there was a trace reporting system. And this reporting system takes in fixed income security transactions, and they're required to be reported within 15 minutes of the execution of the transaction, so that it can help bring more transparency to the public market, and so that the regulatory community, academics, and others, people can see what these trades look like, how often they're happening or not happening. And it was decided that that needed to be revisited by Gary Gensler. And so Chair Gensler called in FINRA and the MSRB and told them, move this timeline down to 1 minute. from 15. Well, why? Well, I want it moved down. Well, what's the purpose? Was there a market failure, or is there some other rationale for doing this? No, I want it moved down. So they put out comment. We write comments saying there's no market failure. There's no issue here. There's no economic analysis or data that would suggest that this is going to improve anything for anybody in the market, especially in the fixed income market where trades are so episodic. And when there is a trade, for me as a retail investor, I might be looking at something that trades in a $10,000 or $50,000 increment. If I see something that trades for $1 million, I can't get that price. I just can't, because it's a volume-based service. And so it's not really useful to have trades reported immediately in this kind of a marketplace, because the trading is so sporadic. That being said, it is good to have reporting requirements. We didn't object to the reporting requirements, except for the fact that they wanted to move it down to 1 minute. We just saw no cause for that, and we repeatedly said it. And we told them, if you move forward with this, we're going to bring a lawsuit. Well, Gary pushed them very hard. They brought the final rule right before the election. They decided that it was the right time to do it. And then Chairman Gensler delegated the authority of the commissioners, which I also think is illegal. He's usurping the ability of a presidentially appointed commission and Senate confirmed commission, taking away the prerogative of each commissioner, delegating that authority down to staff, and then they make the decision based upon this SRO proposal that came out. So there's a couple of different legal issues here that are very unique. And that actually came up, and the SEC tried to do a motion to dismiss, saying that we hadn't exhausted our remedies by asking the full commission for a review and so forth. And we said this was an illegal delegation of authority. I think that's a big problem for not just SROs, but all these regulatory agencies are taking the power away from those who we can hold accountable, or at least Congress can hold accountable, and giving it to people who aren't accountable. I think, and it's probably not fair to the staff at the same time to put pressure on them to then approve these rules. So then they approved the rule, and we sued. And our lawsuit basically said, you have done no economic analysis here. You haven't done a cost-benefit analysis. We told you what the costs were going to be. We also told you the impact on competition that was going to take place from this, because it's much easier for larger firms to absorb this than it is smaller firms. There's a technological impact. There's a cost impact related to the technological change necessary. And quite frankly, a lot of these issuers that we service are extremely small. They could be churches. They could be small towns. And not a lot of people buy their bonds. It's mostly local folks that do that. And it's a lot of telephone discussions to get people to purchase this stuff. And that doesn't always exactly happen, even within the 15-minute time frame. And there is some exceptions for manual transactions. So we sued, and then we get to a point where FINRA said, wait a minute, we will, because we had to sue FINRA and the MSRB. These were joint rules. FINRA comes to us and says, yeah, we realize we made some errors here, and we want to make this right. So Robert Cook puts out a public blog that says we do not intend to set up an effective date for this rule, and we intend to file amendments with the SEC to try to fix this rule. And many inside the SEC knew that the rule was done sloppily and in a hasty fashion, and they aren't surprised by the fact that they're having to revisit it so quickly. Well, the MSRB decides, well, we'll put something out that says we'll delay the effective date, and we'll think about whether or not we should even do any amendments. So we just said, fine, if that's the way that you're going to handle this, then we're going to keep moving forward with our lawsuit. So we filed our brief, and our brief is very clear as it relates to our issues from an APA standpoint with the rule that was put forth and approved by the SEC. But it also is very clear on another issue, which is, even if you found that the rule was okay and actually conformed to the guardrails that Congress put in place with respect to rulemaking, this entity is illegal. And the entity is illegal because the board is not appointed by the president. It's not confirmed by the Senate. The Congress delegated its authority, its policymaking authority, to this nonprofit body that has no oversight at all, other than to submit rules to the SEC, which is supposed to satisfy the constitutional prerogative that the executive, the unitary executive, is taking care that the laws be faithfully executed. We just don't see how that's possible here. If you remove the head of the MSRB, the CEO, then someone at the MSRB gets to reappoint that person, not the president, not Congress. And then the funding model relies on fees from the broker-dealer community, but also it relies on fines that FINRA collects on behalf of the MSRB. And I'll just explain that very quickly, and then I'll let you ask some questions. So the MSRB creates policy. It's then approved by the SEC. Then they consult with FINRA, who enforces their policies on broker-dealers. And then they get to collect some of the fines that are taken in by FINRA to use for their operations. They don't do any examinations. So this is a long-winded way of me saying that this really is a unicorn type of entity, nothing like we've seen in our government. And to the extent that it went away, it would have absolutely zero market impact. Whereas people could make the argument about FINRA, there could be a gap there, there's a hole for a little while. In this case, there isn't. These are SEC rules that don't go away, and you have someone else examining and enforcing them, and including some of the bank regulators in certain circumstances where banks hold municipal bonds. So there is absolutely no need for this duplicative regime. Congress set it up very specifically, and it's when we, from our perspective, see that SROs or whatever the MSRB is acting as an instrumentality of the government, that's when we step in and say, no, we're not going to deal with that, because if we're going to get regulated by the government, then have the government regulate us.
Right. Then at least the lines are clear or clearer. So where does your petition, sort of procedurally, where are you? Is it going to be a briefing schedule on this, or how does it work in the 11th Circuit?
So with FINRA, that case, because of their posture towards us, it's in abeyance right now. With the MSRB, the court just denied their motion for a stay. And so they have to, in the SEC, and I'm sure the MSRB will now be awarded as an intervener. The brief is due at the end of this month, I believe.
Got it. Well, it's like I said, it's always refreshing to see a take that doesn't just attack the rulemaking on the APA basis, but goes further and questions the constitutionality of the entity. It's useful to have those questions asked, and they don't get asked often enough. So we will be watching your case with interest and hope for the best out of the 11th Circuit. I think we'll leave it there for now. Chris, thank you so much for coming on. Sarah, thank you very much for co-hosting. For everybody else, if you want more information about ICAN, go to icanlaw.org, and we'll see you on the next SEC Roundup. Thank you.
Thanks for having me.